While Michelle Langley focuses on the psychology of liberated female sexual behavior, Stephen Baskerville's Taken into Custody details for us the brutal police state machinery which has grown up in the past 40 years to encourage, enforce, and profit from it. Here is the reality behind such commonplace euphemisms as marital breakdown and custody disputes. Quote, a man comes home one day to find his house empty. On the table is a note from his wife saying she has taken the children to live with her sisters or parents or boyfriend or to a battered women's shelter. Soon after comes a knock on the door. He is summoned to appear at a family court within a few hours. In a hearing that lasts a few minutes, his children are legally removed from his care, and he is ordered to stay away from them most or all of the time. He is also ordered to begin making child support payments. An order is entered to garnish his wages, and his name is placed on a federal government database for monitoring delinquents. If he tries to see his children outside of the authorized time or fails to make the payments, he can be arrested. Without being permitted to speak, he is told the hearing is over. The man may be accused of domestic violence or child sexual abuse, in which case there may be no hearing at all. But the police will simply come to the door and order him to leave his home within hours or minutes, even if no evidence has been presented against him. The man may also be ordered to pay alimony and the fees of lawyers he has not hired and threatened with arrest if he refuses or is unable. If he refuses to hire a lawyer, he will be ordered to pay his spouse's lawyer. Either way, he will pay $50,000 to $150,000 and possibly much more. If he refuses to answer questions or pay, he can be jailed without a trail. If he objects, he can be ordered to undergo a psychiatric evaluation. At his trial, he will be interrogated about the most intimate details of his family life, and no answer is correct. If he works long hours, he is a careerist who neglects his children. If he cares for his children, he is failing to earn as much income for them as he might. If he disciplines his children, he is controlling or even abusive. If he does not, he is neglectful. If he does not bathe them, he is neglecting them. If he does, he may be molesting them. All this costs him $400 to $500 an hour, and the ordeal lasts as long as the lawyers and judge wish to drive up the fees. Whatever the outcome of the trial, for the rest of his children's childhood, they and he will live under constant surveillance and control by the court. He will be told when he can see his children, what he can do with them, where he can take them, what religious services he may or must attend with them, and what subjects he may discuss with them in private. He can be ordered to work certain hours and at certain jobs, the earnings from which will be confiscated. If he loses his job or is hospitalized, he will be declared a felon and jailed for failure to pay child support. His home can be entered by officials of the court. His financial records will be demanded and examined by the court, and his bank account will be raided. His children can be compelled to act as informers against him. He can be ordered to sell his house and turn the proceeds over to attorneys he has not hired. Baskerville notes that this very monstrousness of injustices being committed against fathers prevents some people from accepting that they are taking place. A common initial reaction to the horror stories is, if things are really as bad as that, wouldn't we have heard it before now? There are several reasons. One, of course, is that journalists, whose job it is to inform us of corruption in public life, prefer to entertain us with features on gay marriage and movie stars' romances. But a second is that the family courts directly retaliate against parents who attempt to organize or speak out. It is a crime in many jurisdictions to criticize a family court judge. Where it is not, judges can simply issue individual gag orders from the bench. Baskerville reports instances of fathers who were arrested for talking to reporters about their cases. Sheriff's deputies photograph protest demonstrations by fathers groups. Internet sites have been shut down. Archaic laws against defamatory libel and scandalizing the court have been resurrected to prosecute critics. Court officials have been deputized to monitor fathers' criticism of the court in the press and in their private correspondence, which they can be ordered to hand over on pain of incarceration. Meanwhile, officials are free to discuss the private lives of fathers openly in public meetings and post information about their cases on the internet. Family court proceedings occur behind closed doors, and most often no records are kept. In cases where they have sometimes been illegally falsified by unknown persons. Judges cite family privacy as the rationale for secrecy, but in fact, the clerk of courts is required to make plenty of information about defendants, aka fathers, public. Social security numbers, unlisted telephone numbers, and more. They are prohibited, however, from divulging the name of the judge assigned to the case. Baskerville drives the obvious conclusion. The purpose of all the secrecy and censorship is not to protect family privacy, but to allow the courts to invade it with impunity. A third obstacle to public recognition that innocent men are being railroaded is that fathers themselves believe the propaganda about deadbeat dads. Even after becoming victims of the system, they assume some mistake must have been made in their particular case, while other men are the real deadbeats the government rightly pursues. An important factor contributing to this misapprehension is a sentimental view of motherhood and female innocence left over from an earlier age, but now demonstrably at variance with the facts. One writer quoted by Baskerville reports, "All the domestic relations lawyers I spoke with concurred that, in disputes involving child custody, women initiate divorce almost all the time. Men more often attempt to avoid divorce. 58% of men delayed their divorce because of its impact on children. Far fewer women, vis 37%, had this worry." Many conservatives will no doubt agree that strong-arm methods are unwarranted against lawfully wedded and faithful fathers, but protest that they may be necessary against those scoundrels who prey upon women without having been escorting them to an altar. Baskerville, however, cites evidence that even unwed fathers do not normally abandon their own offspring. An American study of young, low-income, and unmarried fathers presents a picture that, while far from ideal, does not show them abandoning their children. 63% had only one child, 82% had children by only one mother, 70% saw their children at least once a week, and large percentages reported bathing, feeding, dressing, and playing with their children. 85% provided informal child support in the form of cash or purchased goods such as diapers, clothing, and toys. Another survey conducted in the north of England found that the most common reason given by the fathers for not having more contact with their children was the mother's reluctance to let them. Here we see one of the reasons for marriage, not to prevent men from absconding, but to prevent women from interfering with the father-child bond. In other words, fatherhood is natural. If shotgun marriages and child support collection agencies were necessary to force men to provide for their offspring, as so many sanctimonious male commentators imply, civilization could have never arisen in the first place. The human male simply cannot be as bad as now routinely portrayed, whether by hate-filled feminists or farcical conservatives. Here are just a few more highlights from Baskerville's relentless catalog of divorce industry injustice. A man in the United Kingdom received a sentence of 10 months for greeting his child on the street. Children have been jailed for refusal to testify against their fathers. A 17-year-old girl was wrestled to the ground and handcuffed by 2 male police detectives for refusal to leave her father's apartment. Fathers have been kept away from the bedsides of their dying children. Custodial parents are not answerable to anyone for use of child support payments and need not spend any of it on the children. States use child support money to balance their budgets or for any other purposes they please. Some states have instituted expedited judicial processes in which fathers are summoned to appear not before judges, but before judicial commissioners or marital masters, essentially ordinary lawyers dressed up in a judge's robes. These persons sometimes double as lobbyists for legislation relating to child support. In Warren County, Pennsylvania, a man was threatened with prison unless he signed a pre-printed confession stating, "I have physically and emotionally battered my partner. I am responsible for the violence I used. My behavior was not provoked." Private companies have been dragooned into performing surveillance for the divorce regime. Employers are required by law to inform on all employees, including those who have never been ordered to pay child support. The information goes into a national directory of new hires, maintained for use against any person who might get behind on child support in the future. This practice annexes the personal offices of private companies as administrative agents of the government. Efforts are underway to make similar use of churches and community organizations such as the YMCA and the United Way. Child support is demanded from men who have been proven not to be the fathers of the children in question. Women are sometimes allowed to collect full child support from more than one man. In the UK and Australia, it has been proposed to outlaw home paternity testing kits available from private companies so that men may be arrested for attempting to prove they are not the fathers of the children they have been ordered to support. Also, in Britain, feminist groups and bureaucrats can bring domestic violence charges against men they target as abusers on the theory that the victim herself should be spared having to take legal action. These third-party accusers do not have to provide evidence that the alleged victim even exists. Some mothers in Massachusetts report being pressured and threatened by social service agents with the loss of their children if they refuse to divorce their husbands. There are now moves afoot to prosecute deadbeat accomplices, meaning parents or second wives or other relatives of child support extortionees. One second wife was charged with harboring a fugitive. Such persons' bank accounts may be seized to pay child support for the fathers they are abetting. Teenage boys statutorily raped by adult women may be held liable for child support paid to those women. In one weird case in Iowa, an 11-year-old boy's savings from chores such as shoveling snow were confiscated by the state in order to pay child support for himself. Possible since, as a minor, his father's name was also on his bank account. Most disturbingly of all to my mind, fathers have been ordered to submit to something called a plethysmograph, in which an electronic sheath is placed over the penis while they are made to view pornographic movies involving children. Baskerville lists numerous legal guarantees violated by family courts, including several amendments to the Constitution, the presumption of innocence, the separation of powers, habeas corpus, and the prohibitions against double jeopardy, ex post facto laws, and bills of attainder. The courts openly acknowledge that the constitutional guarantees do not apply in their proceedings, justified, it is asserted, because they are courts of equity rather than law. Federal courts never review cases involving family law. Family courts are accountable only to review boards dominated by bar associations, i.e., by lawyers with a pecuniary interest in maximizing extortions from divorced men. Baskerville rightly notes an odd circumstance. A vast literature exists castigating the judicial branch for usurping legislative power, ignoring original intent, misapplying the 14th Amendment, and various other sins. But the family court system, which has a greater influence on more people's lives, has almost entirely escaped scrutiny. Feminist ideology certainly played a role in creating the current situation, but, as usual, more was involved than ideas having consequences. Much of the divorce industry's growth has simply been an instance of the normal tendency of bureaucrats to seek to increase their wealth and power. For most of these persons, feminism has been more pretext than motivation. The judges, indeed, promiscuously invoke both the traditional stereotypes about motherhood and modern ideas of women's rights. Probably most have no deep moral convictions at all in the matter. The same gap between rationalizing rhetoric and the reality of material interest is visible throughout the divorce industry, which consists not only of judges and lawyers, but also a bevy of experts, psychiatrists, psychologists, social workers, mediators, custody evaluators, visitation monitors, and instructors for mandatory parenting education and anger management classes. All are paid through forced extractions from fathers. Psychotherapists are ubiquitous in the industry, in part because they fear an insufficient demand for their services on the market. One attorney says, if you put 10 psychiatrists in a room, you'll get 10 different opinions. Baskerville gives just one example. A father was diagnosed by one psychiatrist as having both a dysthemic disorder and a mixed personality disorder, which includes obsessive-compulsive behavior, rigidity, grandiose thinking, and passive-aggressive traits. A second psychiatrist came up with schizotypal personality disorder instead. Such expert opinions are rarely presented in open court, so there is no possibility of cross-examination, and the psychiatrists may be covered by judicial immunity, so they cannot be held accountable for their testimony. As one law professor asks, what made all these people all of a sudden lunatics and unfit to parent? Obviously, the job of the expert is to provide a veneer of rationality for court decisions, which are either wholly arbitrary or made on the grounds such as maximizing the amount of money extracted from the father. If a family court does not have access to some arcane art of determining the best interests of the child, its claim to be engaged in anything more than kidnapping collapses. Pseudo-rationality of this sort is a prominent feature of managerial rule in general. Does anyone seriously believe, for example, that corporate diversity consultants are in possession of some profound science the rest of us lack? It is not altogether surprising that little training is necessary to qualify as such an expert. Courts may appoint persons with only an undergraduate degree or less, 1 or 2 weekend seminars or workshops, and maybe a 4-hour in-service training program. As always, the wielders of power claim the moral high ground. Fathers almost universally report being insulted and harangued with the obiter dicta of judges as if they were naughty boys or juvenile delinquents, Baskerville writes. The New York Daily News produced a credulous report on the parent education classes judges now commonly order divorcing couples to attend. They are said to be necessary in order to, quote, teach them how to behave and maybe even shame them into acting their age.